Hi everyone, and welcome to this event organised by the Emergent Nonfiction Lab at the University of Warwick. Our speaker today is Kelli Moore. Kelli is Associate Professor of Media, Culture and Communication at NYU, and her scholarship examines the role of media and technology in the production of legal and political knowledge within ongoing debates about the subject of trauma and helplessness, facilitated communication, feminist jurisprudence, visual literacy, post-racial embodiment, and the digital. Today, Kelli will be speaking about her new book, Legal Spectatorship, Slavery in the Visual Culture of Domestic Violence, which was published in May 2022 with Duke University Press. To quote Jennifer C. Nash, Kelli Moore's Legal Spectatorship requires us to interrogate the meanings and effects of visual evidence of domestic violence, insisting that we can't understand the call for visual evidence outside of histories of enslavement and anti-black violence. Moore's urgent book demands that we reread the promise of evidence to provide an account of the truth of injury, and that we continue to imagine ways for law to respond to violence. Our respondent today will be Tory Jeffay, who is a postdoctoral fellow in the Society of Fellows at Dartmouth College. She holds a PhD from the Department of Film and Media at UC Berkeley, with a designated emphasis in new media. Her research focuses on the ways visual evidence has been understood and deployed. Her work is published or forthcoming in JCMS, Film Quarterly, and the New Review of Film and Television Studies. So we'll hear firstly from Kelli, then a response will come from Tory, and then we'll open up to broader questions from the room. Thanks, Kelli, and over to you.
Thank you so much. I'm honored and grateful for the invitation to share my work with the Emerging Nonfiction Lab. I come from the disciplines of communication, rhetoric and forensics, and media studies, and I ask how a forensic orientation to the archive of slavery can sharpen the analysis of architectures, acoustics, affects, and documents comprising courtroom activity. So in this brief talk, I'll say a little bit about the methods and stakes of this first monograph, and if there's time, I would be happy to speak about how I am adapting its methods for a subsequent work about the aesthetic criterion through which we might judge and make public our evidence and reasoning about contemporary ways of evidencing domestic violence in art and digital tools. Legal Spectatorship, Slavery and the Visual Culture of Domestic Violence traces the rhetoric of the term domestic violence in order to unsettle, for Black feminist abolitionary purposes, the dominant understandings of domestic violence, wife murder, intimate partner abuse, and so on. It does this work also with the camera obscura, notions of the cybernetic, and the poetic. The dominant US literature on domestic violence has said that the problem does not know race or class. Domestic violence can happen to anyone. My first book sought to complicate this idea by centering the figure of the enslaved in US law, art, and culture. My purpose was to open up a variety of reading practices to create a discursive space to examine what we mean, and have previously meant, by the term domestic violence. My early writing on this project focused on the 1980s, or it's actually rather the early 1970s through the early 1980s. It was this decade of feminist resistance to the female body in performance in order to disrupt the patriarchal structures of viewing pleasure, as well as power knowledge. And I'm about to show you 3 images by artists, by female visual artists, and they are images of violence against women. So I want to preface that, but all of these images are either being cosmetically simulated or enhanced. And then I'll remove the images. And this is a chapter that did not make it into the book, but will make it into a second project, which I could talk about later. So here are those images. One is called Untitled Rape Scene in 1973, which is the work of Anna Mendieta. It was a performance piece based on a murder that had happened while she was in graduate school. The middle one is called Living with the Enemy, which is by the artist Donna Ferrato, artist and photojournalist, who is embedded in a sort of avant-garde couple's home and witness an act of domestic abuse and famously captured it. And the final one is called Nan, 1 month after being beaten. And this was an image by visual artist Nan Golden, who documented her domestic abuse from her boyfriend in 1984 and cosmetically enhanced her bruises with lipstick. I located in these images an important exception to the feminist demand. It was a Marxist feminist demand to remove the body from representation in art during the 1970s and 80s. And I recognized this exception in these three portraits, in these three works. Art historian and critic Amelia Jones argued that the 1980s rejection of the body art practices foreclosed upon the strategic force of the 1960s and 70s Marxist feminist practice of removing the body from art, of removing women's bodies from art. And I expanded her claim to suggest that the dismissal also threatened to obscure a coeval link between those body art practices and the rise of police visual documentation of physically abused women mediated by legal forms of the late 1980s and 90s. From here, I began to launch the main study of the book, at least as the book begins, which is the rhetoric of domestic violence, which I traced through the United States Constitution in this moment called, it's from Section 4, Article 4, Section 4 of the Constitution, which is this moment of the Constitution where the executive powers are being formed. Rather than considering the empirical investigation of domestic violence as a cohesive category that problematizes the couple, in the social and biological sciences, I attended to the German Philological Convention of capitalizing all nouns to open a reading of DV. And what I mean by that at the top here is this lowercase d, uppercase v transforms over time into an uppercase d and uppercase v. The two capitals, the uppercase D and uppercase V, will come to encode legal documents that signify that a criminal court case is a special case, one that legal professionals should take note of, right? Pull these files, do particular kinds of research on these special cases. And I argue that this moment in the Constitution that says the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and on the application of the legislature or of the executive against domestic violence, that originally appeared as lowercase d, uppercase V. So I make a connection between the way in which domestic violence is written in the Constitution and later on in subsequent legal documents that handle domestic violence cases. Domestic violence, lowercase d, uppercase V, meant unseen violence that the executive and legislative branches of government had to protect against. By examining the drafting history of this moment of the Constitution, my study shows that the debate about domestic violence concerned the catastrophe of Black freedom and slavery. So the way in which the Southern states began to talk about domestic violence as this section and article of the Constitution are written, is written, the Southern states argued that for them, domestic violence was the possibility or the catastrophe of enslaved people gaining their freedom. So right away, I could relate domestic violence to the question of chattel slavery. I suggest in this first monograph that it is not possible to even ask about domestic violence or its audience without reference to enslaved people and the many times of slave law. Black folks come to the US culture through the whip, through slave law, partus sequitur ventrum, and constitutional law. It is not possible to inquire about cinematic architecture without reference to its analog. It's another point I make in the book. And thus I come to law, or thus I come to this lab today from the vestibular architecture of the courtroom, the parlor, the hold, and the kinds of evidentiary object subjects circulating therein. I examined the foundational case of Harriet Jacobs, a fugitive slave who hid in a small garret crawl space for 7 years to escape the sexual violence of her masters. Jacobs' memoir recounts that she could see her children playing through a peephole at that time. Jacobs' body position in the garret allowed a cross-reading between the fugitive's hideaway and the camera obscura, the major apparatus of photography and cinematic spectatorship in the West. And here I've shown the cover of Jacobs' testimony about the abuse she experienced as an enslaved person, in addition to Ellen Driscoll, who's an artist who in 1991 captured, it rationalized and imagined the crawl space that Jacobs was hiding in. This crawl space was imagined as a camera obscura, as you can see here, and it had been criticized by an art historian named Huey Copeland for the fact that Ellen Driscoll rationalized this space as if she could really capture the kind of violence experience that Jacobs went through while hiding. Jacobs' body position in the garret allowed for a cross-reading between the fugitive's hideaway and the camera obscura. Jacobs' garret brings fugitive freedom to the camera obscura's figuration of decorporealized vision. Jonathan Crary's idea that, quote, the spectator is a mere free-floating inhabitant of the darkness, a marginal supplementary presence independent of the machinery of representation, end quote. The British novelist Erin Pizzey is credited with opening the first women's shelter in the modern world in 1971 in Chiswick, England, which is about 160 kilometers from where you all are all now. The collision I stage between the camera obscura and the loophole of retreat demands that Harriet Jacobs' time in the hold be acknowledged alongside and even read against the origin story of the domestic violence shelter that censors Pizzey as its founder. Courtroom architecture, containing witnesses, documents, and juries, the camera obscura, and Harriet Jacobs, all confirmed for me a larger fetish for boxes. In addition to feedback loops and closed systems. I turned next to research on the effects of torture, whose findings would be taken up to describe the psychology of abused women in animal behavior studies using the shuttle box, which you see here with the dog and rabbit, and the learning instruments that visualize power and control informed by scientific research in order to contribute to the historiography of cybernetics that centers the slave's ontology and that of her descendants. What theory exactly of the human does media studies and the cybernetic hypothesis presume? I employ a similar archival reading of one of the more obscure papers of Charles Babbage and Norbert Wiener for their attention to the hold of the slave ship in their work and its relationship to the reorganization of labor, work, and the factory floor in their discourses on cybernetics, on their respective discourses. The cybernetic hypothesis was formed through coloniality and the explicit body of the slave, whose body is turned inside out. Finally, I returned to the fundamentally theatrical setup of anti-domestic violence in tactical media. I was interested in how theater makeup in these two images you see here, theater makeup, a major melodramatic form, assists in making abusive touch coherent on photography and film. Building on the chapter on cybernetics, I reconsidered Niklas Luhmann's systems theory idea that law, as with art, is a closed communication system that speaks only to itself about itself. An example of this is in this so-called closed communication is anti-domestic violence tactical media, these examples here, which speaks to theater practices, but also establishes a communication between itself and visual evidence of domestic violence as its quote-unquote special effect. I showed how this tactical media quote-unquote camped the law while simultaneously participating in training courtroom spectators how to interpret visual evidence to the exclusion of other forms of evidence, such as the history of enslavement. Rather than simply read the image of domestic violence as speaking for itself, spectators must disarticulate the relationship between skin color and wounding. In radically reversing the norms of cosmetics, such as here, anti-domestic violence public service campaigns and dark skin establish the visual limits of seeing domestic violence. This is not a mere conflict or trick of the eye, but rather an ontological antagonism between Blackness and visual technology. So I'm going to stop there, but really say that this project was about, among other things, the court as a space of thrown projections, and one of the many kinds of which we might refer to as a poetics of justice. Thank you.
Thanks so much, Kelli. So now we'll hand over to Tory for her response, and then we can kind of open it up to a broader Q&A after that. But Tory, please.
Okay, I think I'm still seeing Kelly's screen, maybe?
Oh yeah, I think Kelli might need to, you might need to unshare
okay,
your screen.
That's slightly less disorienting. Perfect. All right. So Kelli Moore's Legal Spectatorship reads slavery into the photographic practices of the domestic violence courtroom, in tracing a line between domestic violence, lowercase d, uppercase v, as framed in the Constitution as the violence of internal insurrection or foreign invasion, and domestic violence, capital D, capital V, violence between intimate partners within the home. She reads white control of Black bodies into the foundational practice of visual evidence, photography, which emerges in the American courtroom around the time of emancipation. The book's historical breadth is one of its greatest thrills, from slave narratives to the COVID-19 epidemic in the coda. I'll structure my remarks today around two responses. First, on the emergence of the so-called silent witness of the photographic apparatus and its dependence on the figure of the silenced witness, we could say, the enslaved person forbidden to testify. Second, on the forensic photographic practice of reading the body of the victim for evidence of criminality, as Moore nicely puts it, in a seeming reversal of the legacy of criminology, which sought to read criminality off the body of the perpetrator. Following this commentary, I have a series of other questions, but perhaps we can fold those more organically into the Q&A. So drawing on the work of Kimberly Juanita Brown, Moore argues that, quote, slave relations reverberate through format. Black enslavement reverberates through the design and use of automatic machines, end quote. The camera operates like the enslaved person's testimony because it sees, but it cannot speak. In what is probably my favorite quote from the book, Moore writes, quote, historically then, the role of the witness, including courtroom experts, is closely associated with whiteness and mastery, while evidentiary materials share the qualities of accumulation and fungibility that marked the slave's life. She goes on to write, when slavery is made central to the idea of witnessing and testimony, enslaved people emerge as early examples of forensic technology and the knowledge-making practices of silent witness, end quote. We see the legacy of the slave's position in the format of the camera, and yet the camera's claim to both silence and witnessing differs from that imposed upon the enslaved person. While, as Jennifer Mukin explains, photography was introduced into the courtroom as demonstrative rather than substantive evidence, meaning it was only intended to illustrate the witnessing of a human witness, in practice, it operated in a somewhat unruly manner. In other words, while silent, it managed to speak for itself suggesting meanings beyond or in contradiction to the spoken testimony of the witness it was supposed to support. The jury was free to read the evidence as it saw fit. In one encounter between a photographic expert and a lawyer in an 1890s trial that I write about, the lawyer asked, quote, "Now, is it not a fact, sir, that photographers can almost make a camera talk?" He's referring here to a second question of photographic authority, whether the photographer could manipulate the image to say what he wanted it to. The photographer, in this case, denied the charge of manipulation, but embraced the linguistic function of the photograph, responding, "No, sir, but I can tell you that they produce writing louder than a lawyer can talk." It is into this tangle of silence, speech, writing, manipulation, fungibility, and the white-coated gazes of lawyers, jury, and expert witnesses that more provocatively inserts the figure of the slave. In the context of domestic violence, capital D, capital V, this is justified by the enslaved person's position within the white household as privy and often party to the marital discord of the enslavers. What I want to ask here in these remarks is whether we can extend beyond this context, however, to read the slave and the evidentiary camera, regardless of its target, and how Moore's work might apply to these different contexts. So inspired by Moore's usage of Ellen Driscoll's installation, The Loophole of Retreat, which we just saw an image of, which makes physical the resonances between the garret in which Harriet Jacobs hid for years and the camera obscura, I want to look at another work of contemporary art by the Brooklyn artist Cameron Neal, titled Down the Barrel, parentheses, of a Lens. Neal made this two-channel installation while in residence at the New York City Department of Records, drawing on the vast collection of surveillance film shot by the New York City Police Department, largely of protests and demonstrations in the 1960s and 70s. Neal selected imagery from this vast archive that fell into two main categories: shots in which a person being filmed looks into the lens, and shots in which we see behind the lens, so to speak, the heads and tails of reels that show the antics of police behind the camera in the detective bureau messing around. And if it works, I'm going to show a clip of documentation of this piece. God willing. So do you see a screen with a video now? Great.
Yes.
Okay, hopefully we'll get audio as well. So I'll play a couple minutes of this. Do you have audio? Okay, we'll do without audio. It's fine.
Now you've gone full screen. Unfortunately, we can't see it anymore. So, well, unless other people can, I can't.
Are you saying I'm full screen?
No, I'm just saying I think when you click the Vimeo link to make it full screen,
oh, it's no longer showing it.
It's no longer showing us. It's like, yeah.
Let me restart the share then. How's that?
Yeah, I see something. Yeah.
Okay, we'll try that. All right, and I'll stop it there. And since I don't think you had the sound, imagine a droning sound with a sort of clapper at the cut points. Let's see. How do I stop sharing? Stop. Okay. These two types of shots both represent alternative forms of silent witnessing, here in the context of what we could call perceived domestic violence, lowercase d, capital V. Those filmed cannot speak, but they bear witness to the presence of the camera on the scene, engaging the person filming by looking back, asserting their position within the photographic contract. The behind-the-scenes footage, on the other hand, was never intended to testify. It was not produced as evidence, yet it stands in Neal's piece as evidence of the camera's voice, reminding us that the silent witness, prized for its automaticity, is actually directed by the gaze of another. We can see here other ties to slavery if we consider the legacy of modern policing within the slave patrol. And I'm thinking here as well of Simone Brown's work on the New York City lantern laws that demanded freed Black people illuminate themselves when traveling at night, enforcing visibility. The second aspect of the book I'd like to turn to is Moore's consideration of photography and flesh and what I would call a forensic gaze. Through photography, the body of the domestic violence victim migrates through the space of the courtroom, becoming part of the courtroom architecture when projected on a screen, held in the hands of jurors when passed around in printed form. The affective presence of these images can distract from the oral testimony of the victims themselves, as Moore reports, as jurors can ignore the proceedings to look closely at these images. These bodily images are figured thus as both the victim themselves and as a cleaving of skin from body. Moore writes, quote, "When captured by photography, wounded skin achieves another level of materiality, one that is movable, separable, and discontinuous from the body, as if it were a projection or a peeling away of skin." This discussion of flesh and photograph brought to my mind the photographs of the body of Emmett Till after his murder. Not the famous ones of his open casket published in Jet, but the photographs that were shown in the trial of his murderers, which have since been lost, or we might imagine perhaps stolen as a form of lynching trophy. These two images, according to the trial transcript, showed Till's body as it was first found when pulled from the river, one eyeball hanging loose, his tongue protruding grotesquely, skin peeling away from his body. Rather than playing an identificatory role, however, in authenticating Till's body and injuries, these images were used perversely by the defense as evidence that the body could not actually be proven to be Till's. It was so mutilated by the violence committed to it by his murderers and then by the effects of being held underwater for days that the sheriff and the accused all claimed they could not tell if it was man or child, Black or white. The dark skin was attributed to putrefaction rather than pigmentation. And it should just be stated that this was, of course, ridiculous, but that was the argument that was being made. If photography could hide identity in the case of Till, I want to turn earlier to one of the pioneers of forensic photography, the German Hans Gross, who in his book Criminal Investigation, published in German in 1893, marveled at the potential of the camera to see more than met the investigator's eyes, particularly on human skin. Rather than being seen as a threat to be controlled through devices like color cards using the photography of bruises mentioned by Moore, photography was praised for its ability to, quote, reveal fresh details which have not yet been discovered. Taking advantage of differential color sensitivities and filters, the camera could be made to reveal phenomena invisible to the eye. This was an area of great enthusiasm for Gross and his translators, particularly the possibility that the photograph's sensitivity to the colors red and brown would allow it to reveal bodily marks and bloodstains not visible to the human eye. Gross imagined faint signs of strangulation or bruising would appear in the photographed corpse that escaped the investigator's notice on the body itself, going so far to suggest that, quote, "It therefore seems the right thing to do in all cases of suspicious death of white persons to have the corpse photographed as well as the suspected assailant, and to search on the body for traces of redness." End quote. Forensic experts did not expect the bodies of non-white persons to reveal such evidence. Gross's English translators, who are working in the colonial India context, requested that anyone who had experimented with photographing latent red marks contact them with the results, especially with reference to dark-skinned persons. And I should note that this challenge of imaging bruising on darker skin is still an area of active research within forensic nursing. But to extend beyond the question of reading flesh, I wonder here too whether we might read the camera's forensic insight, its perceived superiority to the eyewitness through the legacy of slavery. I'm thinking here now of Fatima Tobing-Roney's discussion of third eye perception by marginalized people, which draws on Du Bois's idea of double consciousness. While not wishing here to attribute consciousness to the camera or to attribute fantastical powers to the enslaved, I wonder if we can't connect this double-edged fantasy and threat of the camera's perceived superior vision to the experience of the veil and Du Boisian second sight. Can we argue that a forensic mode of seeing stems from a racialized mode of looking? So those are my two main provocations for discussion. Say thank you, Kelli, for this fabulous book, and I look forward to hearing the response as well as all the questions from the participants.
Great, thanks. Thanks so much, Tory. Yeah, I guess Kelli, it's the floor is yours again if you want to respond to the response as it was, but and then we can perhaps kind of like open things up to kind of broader questions from the room.
Sure. Thank you so much, Tory, for those questions and for those provocations. I'll start with the Down the Barrel series, I guess is that it's called. I'm not familiar with that footage. It was really interesting to see. It made me think about, sort of made clear for me yet again, the ways in which, as far as domestic violence is concerned, the police really had to learn to take those images, right? And learn to be invested in them. And they were successful in that. And sort of one thing that I often, remark about in my writing or presentations is the fact that the police investing in taking these images of battered women was very helpful in getting something done, of course, carceral, about domestic violence. And so there's this weird, I always feel like I'm apologizing for the cops, but that's never my intention, but rather to say they did have to sort of learn to see taking pictures of battered women and developing and kind of making a note in their own documentation about how to do it. They really had to learn to invest in doing that. So something that we should just think about, and what that I try to think about in terms of a way of reversing some dominant strains of criminology, as you very nicely put it, which is to really be focused on disclosing the body of the criminal, and even to sort of wonder about how to identify other criminals, which you can see in the pseudoscience of photography, right? Once photography is incepted. That footage also recalls that one of the big methodological decisions that I had to make in this book, which was really kind of difficult to make, and I was really insecure about it for a long time, had to do with the fact that this book isn't really a book about battered women. It's not about their lives, right? It's not an ethnography of their lives. I don't visit their homes. I kind of had a policy when I was in the field and I was watching domestic violence trials that I wasn't going to reach out to court respondents, to victim survivors. If they talked to me, I would happily respond, but it really wasn't about following them around. And the theory for that for me was that technically, when I'm in the courtroom following these trials, I don't really know who all of the battered women or battered people are, right? It could be the witness on the stand, but it could equally be the judge. It could be any of the lawyers, right, on either side, jury members, et cetera, right? So this is yet another reason that I was more interested in exploring what the photography, right, what the evidence does, who touches it, how do people talk about it, how do people think about it, and where does it come from? So that footage that you show kind of reminds me about some of the decisions that I had to make, which I say I was really insecure about. But they're there's a ton of work with battered women that talks about finding women shelter, explains, the kinds of decision-making patterns that battered women often have to engage in. There's some really wonderful work about that, but that's not quite what this project was about. And this reminded me of that. So my methods were really about following the people with power in the room, and those were all of the law professionals. I was interested in judges. I was interested in both sides of the attorneys in these matters, the court officers, and as I said before, how these images are passed around. Just going to sort of go back to the notes I was taking. And this question about the third eye, I think the answer to your question is yes. There's certainly that link. The fact that you're sort of you draw our attention to Tobin Roney's work. This project is an Americas centered project, but I do hope that it does offer some ideas or inspirations for people to examine these kinds of matters in other places in the world, particularly around following the development of legal terms such as domestic violence in their own respective constitutions or other legal documents. So I hope that the book can be a way of inspiring, future projects, as I've been inspired by some of those projects too. And really that, your provocations also helped me realize, you've kind of highlighted the silent witness thing more than I did in my opening remarks, but there's really a way in which the camera is very much tangled up in the question of fungibility, right? The camera as a technology itself, and any kind of image that it puts out, and the ways that we are encouraged to read them or not read them. So thank you very much for kind of helping to kind of highlight again the ways that photography is integral to the concept of fungibility and accumulation there. Yeah.
Great, thank you. Thanks, thank you both for such a kind of a rich discussion. If people, as I say, if people want to kind of raise their hands to ask a question, there's space for that. I don't know, Tory, if you wanted to respond to the response to your response.
I don't necessarily need to respond to the response to the response, but I'm happy to open with a question while people are formulating their questions.
Thank you.
Which is a little basic, but something I wonder about whether it is merely contingent on the context of DV, or there's something larger in terms of how you think about the difference between the still and the moving image as evidence, and that link, whether there is some break or continuity there for you.
Yeah, I think you can still get into the same kinds of conundrums that you talk about with the Emmett Till case, particularly the Rodney King. I mean, that footage brings us right back to your question, and the different ways that that both sides of the law argued for how we should see or how we should read the moving image. I don't take up the moving image in the book. It's really about the still. But yeah, I think it's very much in the same realm. I think in subsequent work, I've not sort of moved more into film, but rather begun to think about digital tools and the question of domestic violence. So this is a growing area of research that's called, it's by a woman named Anastasia, and I'm blanking on her last name. Sorry about that. I'll try and find it. But she's come up with this idea about looking at rape cases, particularly among college students and young people, where perpetrators and spectators of these kinds of events, gang rapes in some cases, would photograph and record some of what's happening and then release these things online or to a circle of people. So there certainly the moving image is in play. But what I've become more interested sort of beyond the sort of cinematic aspect of it is the ways in which people take up a kind of rape justice or even domestic violence justice that has to do with really making calls about how this kind of evidence begins to circulate. And so this becomes proof that's not about bringing someone to a trial, but rather thinking about alternative ways to think about the question of justice in these matters. And I've begun to think about that, particularly around a tool called Callisto, which is developed by a legal scholar as well as a victim of campus rape. And so this is a tool that kind of gets into all forms of entrepreneurialism online with making digital applications. And it's an application that is focused on college campuses, and it's focused on research in college that sort of shows the way that rape and forms of physical violence and sexual misconduct occur on campuses. And they occur through perpetrators who share the same victims or victims who share the same perpetrator. And so what's been invented is an application that allows victim survivors of rape, of campus rape, to log in their complaint. Which is not about talking to the police, and it's not about talking to campus administrators or nurses or things like that, but it was about logging in the fact that something happened. And this hits on the fact that a lot of victims are not ready to take any kind of legal action because they're not, in some cases, sure about what happened, right? And so I've become interested in these kinds of tools such that they ask for or they allow people to store a complaint that only becomes active in the event that a victim shares your perpetrator. And so then you will get a notice in the event, and it could be years or weeks or whatever between this happening, if at all. And then it's an application that creates a match between two victims. And so it's based on some of the same theories of dating apps, but again, kind of reverses them in a similar way that I discuss the ways that images of domestic violence reverse our attention to the criminal and getting us to think about the victim. So I've begun to think about that and kind of digital tools that are about finding means of rape justice rather than necessarily going through the traditional or what's become the traditional response in talking to the police and in initiating a investigation and that leads to trial, et cetera. So I thought about those things. As well as the ways in which a new generation of feminist artists are beginning to take up domestic violence images as art, right? Which I think in some ways will take us back to lynching photography and the ways that that painful archive can also be taken up as art, as Lee Rayford talks about in a really wonderful article about that.
I have just like a follow-up question on that in terms of the distinction between domestic violence, which obviously you trace this lineage in the term itself, and then rape, which is not necessarily within a domestic context. And is that significant to you? And it was interesting to hear you talk about this app in which you are matched with like a shared victim or perpetrator. It's that it's like sort of recalls a sort of familiar or like a sort of bond there, so it sort of came full circle. But yeah
Thank you for pointing that out. In the book I do collapse those terms, and it's based on an assumption that I feel that I can feel secure in making, which is that if you are into domestic violence abuse in the sort of traditional couple scenario, there is no reason that you're necessarily in control of the sex act, right? And that it's not always a sex act, but rather an act of violence. I assume that those things are of a piece in the world of an abusive relationship. My sort of more recent attention toward this app and the question of rape justice really kind of expands from this first book to argue that there's something about the space of the college campus in which old relationships of the plantation again reassert themselves. You know, where I can argue that the courtroom is actually a space where that can be divided between masters in terms of the court law professionals and the space of the jury and witnesses and courtroom audience. Those are, if I can argue that those things are connected to enslavement, then certainly the college campus, where people are away from home, sleeping at campus. I can argue, do the work to connect those two spaces, and to suggest that what the crime of rape does on college campuses is affect the labor of the student who's there to work and to aspire, you know, through an education to, you know, a particular kind of, you know, profession or work thereafter. And so this is an argument that talks about the way in which victims can use these apps as a kind of way of organizing, almost union organizing, right? Which again is not necessarily about seeking redress through the courts, but about making the connection between victims who may or may not choose to be in contact at some later time. But I really try and use this idea that there's a kind of union organizing of victims or among victims here that is mediated by this app, in the same way that the circulation of images of domestic violence, like the ones that Donna Ferrato was doing that I showed at the beginning, marshals and collects victims into certain forms of activism and redress. So yeah, the connections are certainly there.
Yeah, are there any other kind of questions from people in the room? I guess, Kelli, I was wondering if I might be able to ask you to kind of just talk a bit more about the kind of, I guess, the kind of material process of actually doing the kind of ethnographic work in the courtrooms, just as a kind of, as someone who's not really done kind of a ethnographic practice like that. I was kind of interested to, just to kind of understand the kind of like the method that you kind of used, or like how you kind of accessed those spaces and the kind of framing, and you know, choose any of those to talk about that you want. But
thank you. So part of this work was archival in reading, you know, Southern horrors kind of stories, old stories about lynching, and thinking about that. But then there was also a component an ethnographic component where I was following domestic trials for some years. I chose to follow them in the misdemeanor courts. And the reason I did this is because I got really interested in what kind of visual evidence you would have in an area of law, or an area of the criminal law, where the cases don't mean very much, right? If it's a misdemeanor, it's things like public urination, public drunkenness, theoretically victimless crimes. But there are also misdemeanor domestic violence charges, and those cases have evidence too. And so I was interested in what the quality of the images, or what the quality of the wounding would look like in photography. So I was doing ethnographic, I was sitting in on these trials, as I mentioned, in order to do that. And if you've never done jury duty before, or if you aren't someone who hangs out at courthouses, it's both incredibly interesting and boring at the same time. And if you're sitting in the courtroom audience, you realize that the courtroom audience is not just in the courtroom, but rather there's a courthouse audience. So spaces like the hallway become very interesting for observing speech or moments of interaction between clients and lawyers, or even opposed parties as they pass each other in the hallway. All kinds of things happen there. But then in the court, my problem, in the midst of this sort of boredom, not always understanding the legalese, not always understanding the moment in a trial, the kind of mechanical ways of speaking. I had to turn to drawing, actually, to begin to take notes about that. So it wasn't just jotting down words, but drawing became really important. And so what I was doing, I later realized, is something called court watching, which has been around for a long time. And there's new work and books coming out about court watching. And I've developed a second project where I bring students of my forensics courses into the courts, and we draw together. And there's sort of no way, it's not really about overcoming the boredom, but about a way to sort of confront the onslaught of information that's coming to you. So bringing a notebook to courtroom, this is a long way of saying that to bring along a notebook to courtroom and draw. The other key detail about that, I should say, is that there are no cameras allowed in the courtroom. So you're really sort of, in terms of a courtroom audience being able to produce a certain kind of knowledge, right, or even develop its own legal history of taking notes and making knowledge from the pews of the courtroom audience, is something that's not often done. Sorry, I'm losing my train of thought here. And it's predicated on not being able to record using a camera. So that the kinds of recording devices in Western courts, it's a steampunk environment essentially, right? You can only draw. You have the pencil to mark in this way, to mark in the space where courtroom respondents are being marked, right? So it's marking versus marking. And that's kind of been a key method that, as I say, is carrying on to other work. Yeah.
Wow, that's so fascinating. Just that, maybe just to kind of follow up with that, I'd just be curious to hear like how those, what of the kind of the students in those classes that have been engaged in those kind of drawing practices. I mean, have you found that kind of like sounds like a really productive kind of activity?
It's amazing. Because they're college students, many of them have never been to a court before. My campus at NYU is a very international campus. So I have a lot of students who maybe have courtroom experience, but not an American court. And so there's some interesting things that happen there. And what I'm interested in so I've begun to collect these drawings, and I have them, a number of them. And for a while, the question sort of became, well, what are these? Because the drawings are sometimes they're stick figures, right? I don't require that. The project operates on the idea that everyone can draw, right? But I've begun to think of what do I have, or what do we have in these images, and how should they be read? And should we be understanding these images as art? And I'm interested in that possibility, but I'm less interested in reading them as good art. I'm less interested in that. I'm interested more in reading them for how students comprehend and develop a kind of legal consciousness, or rather a disclosure of legal unconsciousness might be possible. So I'm interested in what you have in the drawings, what's there. And I find when I look at them that a number of the students bring certain viewing practices into their drawing. So for example, there are students who are sort of immediately able to storyboard what they're seeing, and they really organize their drawings into things that make sense in a way that the courtroom doesn't always make sense, right? But you get these really sort of almost comic book-like storyboarding. And I find then that it has to do with students who have a history or a practice of reading manga, right? So there's all these aesthetic practices that people will bring into these drawings. I had a student who was a practicing Muslim and did calligraphy, and they do an extraordinary drawing of texts that you would find in the courts that looks like that kind of calligraphy that you might see, which is these historically very beautiful forms of calligraphy in Islamic practice. So those are the kinds of things that I've been finding, and I'm at a point still where I'm trying to build a theory or a framework for how to handle those drawings and see what they are, a way to talk about them. Yeah. Does that answer your question? I think I got lost.
No, yeah. I was kind of just curious to hear some more about It sounds like a really fascinating.
Yeah. It's making me very happy.
Follow-on project.
A depressing book. Turning to drawing and artists is how I've ended up. Yeah.
I can ask another question if we still have time.
Yeah, sure.
Okay. Sure. And Kelli, I'm interested, we've talked in the past about the fact that, the majority of cases don't go to trial. And I was thinking about the fate of images produced in those circumstances, as well as the vignettes that you offer from talking to the forensic nurses who discuss, the patients who want to see the injuries versus those who maybe aren't planning to leave and don't want to see it. But I'm curious if the images that don't end up projected or thrown anywhere, if you're interested in the sort of meanings there, or if it's more about the space of the courtroom and the audience for you.
Yeah, thank you for that question. The book is really about what's being thrown in the courtroom, and some of the aesthetic practices that go on, as you mentioned, in terms of a forensic nurse showing the image to a victim survivor and having that person have a very different reaction, having that person react in a way that is new somehow, given the life that they were leading previously. But in subsequent work around artwork that comes about that has these kind of domestic violence themes, I begin to imagine an afterword for those images. So I'm publishing in the SCMS, Society for Cinema and Media Studies. In the spring, I'll have a piece coming out that's about two artists who do a kind of artwork that is domestic violence artwork. I'm going to try and show it to you. But that, can you see these? This is an artist named Letitia Key, and then she makes these domestic violence hair sculptures. Here is an artist, Eleanor McNair, who has replicated Nan Goldin's famous portrait. She works in Play-Doh. And I talk about these in order to show a kind of afterlife of evidence. And the article is called Evidentiary Afterlives. And it takes off from a program in Long Island, New York, where police wrote a grant and got some funding to purchase a whole bunch of Polaroid cameras in the 90s. And that is how, in this township in Long Island, how police began to invest and take pictures of and invest in this kind of knowledge-making practice, right? In going to, responding to a domestic disturbance call and showing up with Polaroid. These artists, I argue, take off from that kind of work. in a different way, right? Using a different materiality, and I make a different argument about that. But what it brought me back to was the fact that when courts all over the country began to invest in these kinds of photographs, the photographs would also end up lost. Any photographs from a trial will end up kind of packed up in a case folder, usually not necessarily the originals, but a copy. And they're packed away in the court documents. So when I was doing the courtroom piece, I would then trace or track that case into the files, and I would go talk to the file clerks and have them pull certain cases. After a certain amount of time, though, all that stuff is destroyed. In very much according to the arguments of Cornelia Wisman, who talks about the ways in which law effaces and strikes out and nullifies all sorts of forms of evidence and speech. So these artists, I'm arguing, are kind of taking off from those kinds of practices when they represent domestic violence evidence and its sort of evidentiary aspects when they kind of turn them around into an artwork. And so those two artists that I showed you are two artists who are in that vein. Is there someone who's had a hand raised for a while? I don't know.
Yes, Pooja, if you, go ahead if you want to ask your question.
I think, Kelly, you're still sharing, I think.
Oh, sorry.
Oh, yeah.
Hi, folks. I'm going to stay off camera because my bandwidth is so terrible. Are you able to hear me?
Yeah. Hi, Pooja.
Yeah. Hi, Kelly. Hi, Tory. How wonderful to see you both, and such a pleasure to listen to you in conversation. So I'm going to take us back into a mise en abîme of talks and responses, because I had the pleasure earlier of listening to Kelly's talk several months ago, where not Kelly's talk, Tory's talk. We were reading two trials that involve photography. One from the earliest days of photographic evidence, and then you were also speaking about 3D modeling and the Rodney King trial, and making a case about forensics as a kind of racially motivated strategy. And you had framed your talk as a Black history of forensics. And I recall Kelly suggesting that what you were offering was more along the lines of a forensic history of Blackness. And at that time, Kelly, you were kind of talking about this project that you were working on and speculating as to whether that's what you were doing, a forensic history of Blackness. And when you framed your comments today, and when you were speaking about, kind of framing your, the chapter in Legal Spectatorship on Harriet Jacobs and her kind of perspective from the garret as somehow emerging into some of these aesthetic interventions, which are all kind of belated, right? Like they're dealing with the fact that the camera is not permitted in some way as a kind of evidentiary tool, and they're kind of working in that context. And so I wondered if you might describe what you are doing now, when you said kind of thinking about aesthetic criteria to make public evidence, or shifting even categories of what counts as evidence, if you would describe that as Black forensics or counter forensics or something like that. I don't know if this is a productive question, but it was spinning around in my head and I thought I'd ask.
Yeah. Should we both answer, Tory and I, or I don't know.
However you wish.
Yeah. I think I do see it as a forensic history of Blackness. And the piece that'll come out in the spring, that article is kind of divided between doing two things. One is to talk about this program that was out on Long Island, which was called the Polaroid Evidence Project, or PEP, and it's to talk about that. The overall theme of it's a special issue, and the theme is like forms of evidence that were not shown very much, that are unseen, that are lost, that are not often talked about. And these artworks, I'm suggesting, take off from the fact that while trials are public and we can all go and see them, it is not, and we can also get access to court documents later, that being able to do so is not so easy, right? You have to have time from work to be able to hang out in courts during courtroom, operating hours. So that's one. And two, being able to get that information because of the reasons that I mentioned before around keeping these images for a discrete amount of time. It's not so easy to get a hold of these images or to be in their presence, right? And so outside of that comes this kind of growing set of artists who are beginning to think about evidentiary forms of evidence, but in an art realm. So you had Letitia Key, who uses hair, but she's using black hair, which is absolutely a part of the ways in which enslaved people have been abused and controlled through law, through other acts of violence, etc. You have Eleanor McNair working in Plato in a way that replicates Nan Golden's evidence of being wounded, and replicates it in a way that might be considered rude by some, right? How could you, because her Plato version doesn't do justice to the portrait, and she works in Plato, and she copies iconic photographs, and very often none of the Plato renditions do any justice to the iconic photographs. And I think that's okay for her. Like, she's not interested in making good art in that sense. It's much more conceptual. What she's interested in us doing is returning to the original and figuring out what the nature of the original is. And I'm interested in that question, I guess, from a perspective of doing a forensic history of Blackness too. How is it that we can return to the images? In the article, I make this connection between these two artists and this larger philosophical question of puzzles of material constitution. These are puzzles in philosophy that help us understand the nature of identity, the nature of knowledge. So things like, if I have a lump of clay and I call that lump of clay lump, and then I use that lump of clay and I turn it into the statue of David, is the lump of clay in David? Is clay, so are clay and lump in the statue of David? In what way are those things bound up in each other? And in what way does, clay survive the statue of David being destroyed, and a lump might not survive it? So it's this larger question in philosophy that really gets, that I'm suggesting these feminists, artists who are thinking about domestic violence are also doing a similar thing. Maybe it's nonsensical now, but wait for the article, it makes sense there. Where how do victims or how do artists make a kind of image or thing, and what survives in this new evidence? I guess that's kind of the question. And it's based, if we're thinking about experiments, if we're thinking about these puzzles of material constitution in philosophy, then you'd have to admit that all of those puzzles turn on the question of destruction, right? What survives the destruction of a particular mass, right? Does the clay survive when you destroy the statue, for example? And I think that question is still alive in the artwork that some of these artists that I'm following are doing. Which is to say that if philosophy is based on a series of experiments of destruction, if that's how we can make empirical or if that's how we, base epistemological claims, then how do we then ask a similar question around evidence and what survives of the victim's experience and the different ways and needs that people have to voice that experience in some material way? Somewhere in that is an answer to your question. But stay tuned for other stuff.
That's beautiful. Thank you. Thanks for responding.
Sure. Thanks for the question.
I'll just say that, Pooja, your question is making me realize that I think maybe against Kelly's will, but I keep trying to read Kelly's work as this forensic history of Blackness and expand it beyond the domestic violence context, and to the extent that in writing the response, I almost felt as if I was being somewhat disrespectful to the work, because there's that piece is obviously integral to it, but I think it just speaks to how generative your work is in a larger sense.
If you can expand it, thank you for doing so. I have for a long time thought that this was a very odd book that's hard to place. And if I'm really, it really excites me that you can see a beyond to the work and a beyond for applying some of the methods to it. I really appreciate that. Yeah, because I think it's a totally weird book still.
Great. I mean, unless perhaps there's any final questions from the room or from, yeah, if not, I'd just like to say thanks to you both. It was nice to do a inverted book talk. I think that's quite a nice phenomenon. But thank you so much for both taking the time, and for thanks to the people in the room for questions, and yeah, thanks so much. And it'll be made, the recording will be circulated, so if there's parts that you missed, then I mean, if I'll double check, I'll send it across to Tory and Kelly for their sign off, but then hopefully we'll be able to share it online. So thanks so much, everyone, and yeah, have a
Thank
good
you,
day.
Patrick.
Thanks
Thank
for
you.
All right.
coming. Have a great weekend.